Thank you for joining us here on Law and You. I'm Wuyi Agmofwegwe. As always, it's a pleasure to have you join us here on the program. The fight against corruption, if you like, GRAFT in Nigeria stands on many legs, and obviously for a wide range of reasons. A lot of persons have talked about how that corruption in itself is endemic, it's systemic. If we don't kill corruption, corruption will kill us. We've heard several things about corruption, but incidentally, people are more interested in the fight against the monster now known as corruption. Just a few days back, the acting chairman of the commission, that is the EFCC, the Economic and Financial Crimes Commission, had appeared before a committee of the House of Representatives to talk about, to defend budgets, their proposal, their budget proposal for 2021. Of course, in the middle of that interaction, several other issues that are very germane to the danger of corruption, the danger it poses for Nigeria as a country, and what must be done to be able to address it, also came up. One of them was the fact that for us to fight corruption successfully, to a very, very large extent, there has to be establishment of special courts that will exclusively address or deal with issues of corruption. Of course, that call has been here for quite a while now. But the second thing again was that the conversation about having to retain 5% of whatever the anti-graft agency recovers is also a necessity, given the fact that the Federal Inland Revenue Service, for example, as well as the Nigerian Customs Service, also do the same. They retain a percentage, 5% we understand, from all of the revenues that they generate. Then the question of whether or not the EFCC is quote-unquote a revenue-generating agency of the federal government becomes pretty much of a debate. Apparently, that's the reason we want to have the conversation on the program today. My guest is a lawyer, and in a bit, he'll be telling us what the elements are as far as this issue is concerned. Stay with me. Barrister Matthias Obayiwana, it's always a pleasure to have you here on Law and You. You and I have had time again and again and again to talk about anti-corruption in Nigeria on quite a number of platforms. But this time is a bit different because the leadership of the EFCC itself is now calling for special courts to say, look, going forward, that is the direction we should be heading in. Have you ever taken out time to think about the necessity or otherwise of special courts?
Yes. Though most of the EFCC matters are often done at the level of the Federal High Court,
okay,
which was also a federal court, for revenue matters. Granted that there are other matters that do go to the Federal High Court, other than purely criminal matters for EFCC matters. And then those other cases, when they come up, we have a way of also slowing down the process. So I subscribe to that move or agitation or call for a special court,
right,
to enable fast-track proceedings, just like it is done for election petitions cases, where sittings are adjourned, from day to day, and it's time bound.
Yeah.
So you must do your matter and they conclude within a specific period of time. So you are bound to come day to day. Sometimes public holidays, we do go to the tribunal to ensure that you conclude that case before
within the window
it expires. Yes. So that is exactly what I think they are also calling for. So if they create a special court, and then you know that all the cases in this court have to do with EFCC matters,
right?
Money laundering, financial crime related cases, and so the excuse will not be there to say that you are coming to the court, you cannot. That was the reason why also we also have a National Industrial Court, which shall also be a special court set up for industrial relation matter. Because if you mix up with other regular courses, it will delay. And that is why I also often called for the need for a special court for human rights cases. Because the hallmark of our democracy in Nigeria is hinged on human rights. So where there is so much violation of fundamental human rights, you mirror the country democracy from that window to say, look, there's so much democracy in the country where there's so much human rights abuses. So we also have a special court for human rights cases, National Human Rights Court, like you have National Industrial Court. Then you are also calling for a special court for financial crimes court, whatever name you want to designate it. You know that these are purely cases that you handle there, and when matters come in that court, you know, they are fast track. And judges that will also be appointed to that court will be that who specialize in this area. Because you find yourself in regular court now, you know, a judge of the high court maybe has to deal with some criminal matters, though they have designated special court for criminal division at the high court in Edo State, for example, now. But the federal court is not so. You have criminal matters coming on there, civil matters coming in there, so also the matters are coming in there. And you don't have a judge who need to have a broad knowledge of all of these areas, you know, to handle. But whereas if you have a special court, like you have for the National Industrial Court, all industrial related matters are coming in there. So before they appoint a judge, it must be somebody who is so versed in knowledge in all aspects of industrial labor related cases.
Right.
So when they bring such matter before you, you know what to do, and you know, you can actually fast track the process. So the same is needed and necessary, you know, to have a special court for criminal matters.
You know, I'm curious, pretty much like most Nigerians, why it has had to take this long. In fact, you and I sit here today, we're still having the conversation about whether or not we should have special courts for corruption cases, especially financial corruption.
Yes.
To the point that even the agency of government, the FCC, has not also joined that call to say, let's have special courts to, in your words, fast track prosecution of these cases. Why does it take this long to have things like this established?
I think the CJN, the National Judicial Council, the executive arm, you know, they must all put on their thinking caps to ensure that the appropriate thing is done. You know, we must be proactive. The idea of saying that we have judges already who can handle these cases, you know, I have had cause to do matters in certain courts, and I find out that the knowledge of a particular judge may be limited because in certain areas, because you have been so used to a particular, you know, line of cases that you have been handling. By the time something else comes in that you are not so familiar with, you have some issues. Then you end up now delivering judgment that may not, you know, or go well, that will not actually do justice. But it was the best of your knowledge.
Right.
You know, so no one knows it all. Yes, they say the law is written according to the breadth of the court, but you must still assist the court by presenting the law and the facts before the court, you know, in such a way that will enable them to reach, you know, a just decision. So if they allow room for special court, you are going to appoint specialized, you know, judges in those special areas who will ensure that justice is done. They know the nooks and crannies, the corner, everything about that aspect of law, you know, is at their fingertips, and then they can discharge judgment, you know, as quickly as possible. So that call is very, very paramount. So they must be proactive enough, rather than bugging the judges with all, you know, with other cases, and not now so to grapple with financial, you know, matters, financial crime cases. They normally consider to be normal criminal cases, and not that anybody can do it. No, they should hire more hands. I can see that there are a number of lapses here beyond just the delays. It's not necessarily caused by only non-specialized courts. If the regular court are well kitted with necessary gadgets to ensure speedy of justice, electronic recording, you know, and all of that, you find that they still record in long hands, and they have a number of cases in their courts to handle. They are human beings. Somebody who will be seated for a while, maybe for 2-3 hours, hearing an argument from counsel from both sides, taking notes in long hands, now having to go back home to look through the decisions that be given, and then come to his own conclusion, giving rulings and final judgment in the matter. So you find that as a human being, they are not machines. Even as machines, they need to be serviced. Right. So when you give them, you know, not too much work to do in terms of number of cases coming in, and then you give them the necessary gadget to enable them to churn out these cases, you know, with the speed of light as much as they can, you find out that things will come up much more easier. So we still sit back, you know, the unorthodox way of justice delivery is what we are still grappling with. Look at the COVID-19 era brought us to the idea of, you know, having to have virtual hearings. Yes. Even at that, since the COVID-19 pandemic is going down now, the issue of virtual hearings also kind of phased out. At the point we're serious about that, there's a need for us to have virtual hearing.
We didn't sustain the commitment.
It is not sustained. It's not being sustained. So some courts took off, others did not. You know, so why can't we not sit down and have a technology hub, you know, in the judicial system, call eggs into this to see how this can work smoothly. You can be seated here. The idea of getting witnesses to come and testify in court, you cannot move them from one point to the other. You know, if there's virtual hearing that is set up wherever location that they are in, hearing can still continue.
Right.
Without necessarily you coming face to face with them. The logistics of moving criminals from, suspect from where they are facility, where they are detained to the court. Then there be an attack on the way by other sort of criminal who try to set them free and all of that. Why can't you can set up a virtual hearing if such a criminal is such such a suspect that people who believe that endangered species or they are dangerous element, it could be virtual hearing. Set up this technologies wherever, and for the court can see it from wherever.
And that is not a big deal to accomplish.
So that's why I think Nigerians should be thinking towards. So working towards, don't just pay lip services to it. The executive or the government must fund the judiciary, fund it to ensure that this justice delivery come in a system where you don't have efficient justice delivery. You are going to slow down pace of development, one way or the other. There's no case you can bring to the court now and expect it to finish within 6 months. To be a miracle.
I'm coming to that already.
To be a miracle. So,
sorry, sir. When you look at our cases, I mean, when you look at certain cases today in this country, you realize that we have a number of them stretching all the way from like 2007.
Yes.
Some of those cases came from when, I mean, just before former President Obasanjo even rounded off his second term in office. And then you're wondering, what could be responsible beyond special courts or specialized courts, for example? Some persons are saying there is so much of vested interests in matters of corruption. Could we fight that off with or without special courts?
Yes, vested interest. We have judges. We still have judges, whose consciences can neither be sold nor bought. Who will deliver, administer justice without fear or favor, despite the fact that sometimes some of them get intimidated, they get harassed, they are afraid to. After delivering judgment, whether they can have their peace, whether the people can start, looking around to find a way of, hacking the here and there. We see have such courageous judges who will tell you to your face, whether you are a government person, no matter how highly placed you are, if you first show that you are neck deep in corruption, your fingers have been burnt, they will deliver justice without fear or favor, and to ensure to serve as a user, to make public show of that individual, and then as a deterrent to others. So we see have such judges. We also have others who are lily liver. We are all human beings,
right?
So not everyone has the same courage, so to do the right thing. So beware that where the judiciary is meant to be independent financially, in such a way that you are not going to deliver judgment today in particular matter where the state interest is concerned, and then you need to lose sleep as to when the next allocation will come to finance certain things in the judiciary.
Right.
Because of course you would have ruffled feathers with the executive or which other arm that's concerned, that's in charge of channeling your finance to you. So you find that they try to tread with caution. They don't want to offend the executive. They don't want to offend certain highly powered individuals or institutions because of certain assistance they are looking forward to. So we should have a system that works. We must not build strong individuals, but strong institutions to ensure that in such an institution of this nature, the judiciary is independent financially. Whatever money that is voted to them goes to them from source. Straight away. Shouldn't come through one executive body or executive arm, straight to the court. And then the heads of court know what exactly to do with that money. So if you're talking about issue of technology now, which is long overdue, core persons who are knowledgeable in this area, how can we wire the entire court to ensure that, like you have in developed climes, I don't see judges writing. You see them, they are relaxed. You are talking to them, whatever you are saying is being recorded. So whatever decision you are making, you're just watching your demeanor and all of that. Everything is recorded electronically. So at the end of the day, what you do is to listen to the record and then reach your decision. In fact, you can make a fairer decision from that perspective, where you are not so stressed in writing, because they are mainly just taking notes, like we dictate to them. They came up to say, look, let us have fast tracking process where you do front loading. So whatever you want to say in evidence should be not put that in the deposition form. You will only just come there and adopt. Then again, you are still going to cross-examine that particular witness. When you are cross-examining the witness, the judges are still going to write in longhand. So you're going to slow down the pace. So it takes us back to where we're coming from. It cannot be obliterated. They will still suffer by taking that note in longhand. Right. So if you wire the oath and make it electronically recorded, the thing is coming up, the judge is just sitting down and watching your demeanor and listening to how you are giving your evidence. Everything is recorded. If there's any objection, you know, except for the court to give a ruling on any objection, it gives the ruling. Everything goes smoothly. Before you know it, you know, judgments are churned out.
We're going to take a break at this point. I mean, you and I have talked off record about these issues quite a number of times, and it's a bit of a composite discussion when it has to do with the fight against corruption in this country, especially now that we are seeing so much of calls as to the need to, as quickly as possible, establish specialized courts that will exclusively deal with these corruption-specific issues. We're taking a quick break now. We're back shortly to wrap it up on the program. I want to talk to you about something. The search lamp often is beamed on the FCC, which is the body that is saddled with the responsibility of fighting graft. Yes. Now, the FCC says, just like the Federal Inland Revenue Service and the Nigerian Customs Service, they also should be entitled to at least 5% of whatever it is they recover, because they are beginning to see themselves categorically as quote unquote a revenue generating agency. Is that appropriate? It's
inappropriate. It's inappropriate even for the customs, for whatever I don't know wherever they got the idea from. I have tried to look through the functions, the establishment of the EFCC and their function. I cannot find anywhere there that they are saddled with the ability to generate revenue. Why should you keep 5%? Are you not being funded by the government? Are there not budgets, you know, being allocated to the FCC for whatever work that they will carry on in terms of payment of salaries, cost of investigation, and the rest of it?
Entire overhead.
Yes. So why would you be asking for to retain 5% of whatever money that you recover? So that would be another drain pipe on its own, another endemic corruption, you know, in itself. So for custom, for maybe the FRS, those ones are in charge of generating revenue
for the government.
The financial burden of running government has become so high, and you now find people in that same office now with that kind of money, that kind of 5% that comes in now. How do you account for it? It's not being budgeted for. For example, there's no budget to see how it will be run because you have already submitted your budget to the Senate and you have approved it. Whatever money that have been approved has been given to you. So the 5% that you will retain, for what purpose? For what purpose? So you already have your expenditures covered up by the budget that have been approved, probably the money allocated to you. What will you do with the 5%? So you find then other members of that establishment enriching themselves. So you see you are fighting corruption. So the case of looting the loot. So the money that is being looted, you have tried to recover it, and then you keep 5% for yourself and you share, and you are being paid salaries. So if they want to say, well, don't pay us salaries, don't allocate any money, no need for all that. So we work on our own as contractors.
And they will become self-sufficient.
Exactly. So whatever money that we work, we will keep 5% of it. If that's what you want, fine. Let them come out straight. They cannot be paid salaries. They cannot be funded by the federal government, and at the same time be retaining 5%. So they are encouraging corruption, you know, in itself by so doing. So a body that is set to fight corruption should not be found in such an arena, you know, that will be suggestive of corruption in itself. So for other organs of government that are already engaging in such things, they should desist from it. If there's a law that has been passed, I am not aware of any that has empowered them.
Within the acts establishing these agencies of government, there's no way it says, for example, they can keep a certain percentage
I haven't seen that.
of whatever they recover.
I haven't seen that. For example, now I've looked through the FCC Act, I cannot find any. So if there are others in other extant law, you know, that allows them to keep 5%, I will be surprised. What are you keeping 5% for when you are being funded by the federal government? You are being paid salaries. Just like you tell the police now to also retain 5% of what? Or the custom. You seize goods, and then you have people to come and sort you out, and then whatever money they bring, then you will not keep 5% for yourself. That is why you know they will not make it to come down hard on Nigerians. So you others will pay money at the border, they are be cleared, and then you find people, custom officers waiting on the highway, still collecting money. So you are turning it to a revenue generating agency. That's why even for the FROSC, Federal Safety Corps, you know, commission, they have also been encouraged to slow down on the issue of issuing tickets. See somebody on the highway, you have violated the rules, you issue tickets, go and pay money. Your main job to be on the highway to ensure that the safety If somebody does not have his seat belt on, you warn the person.
Headlamps,
yes,
wipers.
why don't you have your seat belt on? Why this, why that? You want to try to correct them. Not that to find them at every opportunity, revenue. So you want to see how much revenue you want to derive. Is that what you are set up to be generating revenue? No. So the primary purpose, you must not miss that focus. So the focus for them, you can see the mess now between the FCC boss and the AG Fed. You can see trading blames. You retain certain money, that you recovered. You didn't submit all of them. You bought houses here and there. So I'm sure they are already getting wind and feel that if other agencies can retain 5%, we can actually retain. They may actually be retained 5% without executive approval. Now they want to come out straight to say, fine, if this what caused the problem,
make it official.
Exactly. If that what caused the problem, let's make it official now. Want to be retaining 5%. Send the bill to the Senate. And let's see how they will pass that into law. That after allocating a budgetary allocation to you, paying, financing the establishment, paying salary and everything, they will now allow you to be retaining 5%. To do what? To do what?
I want to talk to you about something. This discussion about the EFCC calling for specialized courts. Some persons say, look, it's just one leg of the many legs within the discussion.
Yes.
That there's the part where they see, for the most part, abysmal prosecution of cases.
Yes.
Where prosecution of cases lacks diligence.
Yes.
And thorough follow through.
Yes.
Are we not supposed to be addressing that long before we start talking about specialized courts?
That is it has to be addressed holistically. Yes, there are instances where cases are investigated shabbily. And at the end of the day, you bring it before the law court. Every offense has elements that must be proved before a conviction can be secured. Where there are lapses, the investigation does not show those elements exist. There's no way. But mind you, under our law, there is proof beyond reasonable doubt, the burdens of the prosecution, to establish the element of that offense beyond reasonable doubt. So, where doubt is created, what the defense attorney or counsel does is to ensure, is to try to create doubt in the case of the prosecution. So, where doubt is created in the case of the prosecution and it's very obvious before the court, there is no way the court can give judgment convicting that individual. And then you come back to blame the court for it. No, you should do your job well, cover all the loopholes, do your investigation thoroughly before bringing them before the court. So sometimes they will do it shabbily. I don't want to suggest that, that maybe they compromise on their own part. Let not be said that we do not arrange it before any court of law.
Right.
So any which way the matter of offense will be committed, we arrange it before the court, but the investigation will be done shabbily. Of course, for the word good, you will be prepared to set him free. Because there's no way, there's no judge what is or onion that we set such an individual, convince such an individual on such shabby investigation. Because that certainly will be created. So the prosecuting agency also have their own role to play, their own homework to do. To ensure that eggheads are put, in investigation department. Right. It is not an idea of trying to extract information by force, by compulsion, by duress. No, you can do your investigation outside of the individual you are investigating. You need not have the person, you need not even confront the person until you have all the piece of evidence against him, then you now confront him. You are invited to EFCC office for so and so offense. And you come, make your statement, you are making your statement, even in the place of your lawyer, you are making your statement, you are free to deny anything you want to deny. They confront you with those evidence, undeniable evidence. You did this, you did that. You sign a document, you transfer this money. For what purpose? And they are seeing all of that. You continue to deny and they don't do so. Of course, you will not expect somebody to commit an offense to just come to honor. Right. But it's not the idea of beating them, tear gassing them, trying to force them to, by using force and duress to get them to confess to it. And then the man says, okay, I did the offense. You get to court, the man says they merely beat me to confess to this offense. Actually, they did not do it. Yeah. Where is your own evidence to show that he has done it? You don't have any independent evidence. You are relying on the confession which he has made to you. So those kind of attitude of investigation should be removed. They must be taught to do the investigation independent of the suspect. Yeah. Do it thoroughly in such a way that it will not fail. You are lawyers. I'm sure they also have lawyers in their. You also have lawyers in their team.
Experienced lawyers.
Exactly. So you should look at the element of every offense. So okay, fine. If you are doing your investigation, you must cover all these elements. You must ensure that you put it before court, put it beyond the before court as to how these elements are be sustained. When you do so, the defendant cannot get scot-free. But when they fail to do so, not guided by law, you all do investigation and bring them to court, wishy-washy. Of course, they will be set free. So they have their own role to play.
Okay.
Like I said, holistic work
approach.
Even the court themselves, you know, also have to also fast track the process. Like I said, I will not blame the court so much because they are so burdened with so much work.
And they cannot work beyond the facts presented.
Exactly, and they can also work to kill themselves.
Of course.
So you must realize the fact that they should give them, you know, less of these cases to do, and then give them more of the
all of the tools.
More of the tools to
that,
get
that they need to do their jobs.
So before you know it, you know, I'm looking forward to a day where you can bring matters to court, whether civil matters or criminal matters, within a space of 6 months. In reality, the matter is concluded.
Okay, so I mean, we all should look forward to that. Again, people are pointing out to the need for the EFCC to up its game, especially in the area of transparency. Especially for an agency of government that is that visible, particularly as far as the fight against corruption is concerned. Barrister Matthias Obayiwana, thank you for joining us on the program today. That's our program. I'm Uyag Mofwegbe. Coverage on ITV continues.